Thanks, Deborah. Keep your applause for the main feature. Thanks for the introduction, Deborah. It's my great pleasure today of introducing our distinguished visitor, the Honorable Michel Bastarache. J'ai le grand plaisir de vous présenter notre visiteur distingué, l'Honorable Michel Bastarache. Just a few words of introduction, a few biographical details. Maître Bastarache has been counsel in the litigation group of Heenan Blakey's Ottawa office since 2008, when he retired from the Supreme Court of Canada, where he served for close to 11 years, delivering significant judgments in many areas of law, including criminal law, administrative law, constitutional law, and certainly language rights. Before his judicial career, Maître Bastarache led a varied and successful career in government, academia, business, and in the practice of law. He's received numerous honorary degrees, awards, decorations. Je ne vais pas tous les nommer, ça nous prendrait une heure, mais à titre d'exemple, il fut nommé officier de la Légion d'honneur par le gouvernement de la République française en 2003 et compagnon de l'Ordre du Canada en 2009. Maître Bastarache is one of Canada's leading authorities, if not the leading authority, on language rights and bilingual interpretation, and it's no exaggeration to say that he's written the books on those subjects. The second edition of Language Rights in Canada was published by Yvon Blais in 2004, but there's a third edition coming this year. And The Law of Bilingual Interpretation was published by Butterworths in 2008. But I think over and above his academic contributions to the area of language rights, Maître Bastarache is recognized by many as one of the most important architects of the principles of interpretation of constitutional language rights, both as lead counsel in many of the leading cases and as Justice of the Supreme Court. In his judgment in the seminal Bolac case, he held that language rights had to be interpreted not restrictively, rather they must in all cases be interpreted purposively in a manner consistent with the preservation and development of official language communities in Canada. Maître Bastarache est perçu à juste titre comme l'un des champions des droits linguistiques au Canada, et sa présence parmi nous aujourd'hui est je crois, un point culminant dans les efforts de notre faculté d'offrir à nos étudiants l'occasion d'apprendre le droit dans les deux langues officielles et promouvoir l'accès à la justice en français au Manitoba. So it's my great honor and pleasure to welcome him to Robson Hall. This morning he'll deliver our Distinguished Visitors Lecture on Language Rights in the Canadian Constitution. Following his presentation, there will be time for questions. Il y aura une occasion de poser des questions suite à sa présentation. Et alors, sans plus tarder, Maître Bastarache.
Alors, merci beaucoup pour cette présentation. I'm very honored to be invited to speak to you today. It's always a great pleasure to visit law faculties and discuss with students on various issues. I think it's important to understand that legal issues often have a very important political and social dimension. And I want in this presentation that's really concentrating on the role of the courts in the development of language rights in Canada to insist on that different aspect. Now, really, to understand the situation of language rights in the Canadian legal system, one must give serious thought to the conditions that gave rise to the Canadian Federation, to the existence of ethnic nationalism in all multicultural states, and in our state, to the asymmetrical organization of power that characterizes our Constitution. In this respect, one only has to think of Section 93 of the Constitution, which is important because it purported to protect religious minorities in some provinces at a time when it was well understood that the authority over religious education comprised the right to determine the language of education. One can also turn to the actual Section 23 of the Charter, which, as you know, applies differently in the province of Quebec. In Canada, there are 5 groups which enjoy explicit constitutional recognition. There are language groups, there are religious rights, Aboriginal rights, and in the case of New Brunswick, community rights. It is, however, linguistic rights which were historically the most important with regard to minorities. And that is because of their political importance, and also because all of the major constitutional conflicts in Canada were arised in the context of language rights. Now, in certain cases, language is an instrument for nation building. This is obvious in the case of the province of Quebec. In others, it's a question of ensuring cultural safety and continuity of a minority. This is the case now at the federal level in Canada and in certain provinces, especially New Brunswick and Ontario. The Canadian approach has multiple facets since it addresses individual needs, but often adopts a cultural and community approach to statutory interpretation. It is important to note that the emphasis in that case is not, outside of Quebec, non-discrimination. It is based on the dignity of the person and equality of speakers. The protection granted to a minority cannot thus be founded on tolerance. It aims at the full participation of the members of the official language communities in public affairs without having to give up their linguistic and cultural identity. The question you will ask then is, are language rights fundamental rights? In Canada, language is regarded as a fundamental element of cultural identity, for sure. The linguistic right is, in essence, the right to resist assimilation. It is very distinct, therefore, from the general civil and political rights that are recognized in international law and most charters. Now, the notion of fundamental right has to be interpreted, in my view, in light of the democratic ideals and the understanding of political legitimacy that has course in each country. In Canada, the Supreme Court has ruled that linguistic rights are indeed basic rights, in particular because they are part of a fundamental element of Canadian democracy and one of the components of the Federation. This was affirmed, as you know, in the Secession of Quebec case. It is of great importance for many reasons, but one of the reasons, in legal terms, is that it has a tremendous impact on the rules of statutory interpretation. Now, it's important to note that the first constitutional protections dealing with language were very limited, both geographically and in terms of their scope. And this was due to the understanding between Quebec and the other founding provinces in 1862. The federal structure provided for Quebec to have jurisdiction over those areas that were necessary to preserve the French language and culture. On the other hand, certain basic rights had to be recognized, and those were really taken from the previous administration, the colonial administration, but they were limited. There was very little discussion in 1867 about language rights. It was basically the status quo. It's also important to understand or to know that the problems, the constitutional problems, appeared very early on and that no satisfactory solution was found in the early years of our Constitution. And one of the reasons for this was that there was, as you know, no Supreme Court, and our Supreme Court was the Judicial Committee of the Privy Council in London, which came down with very inappropriate decisions. In particular, in the Michel case, the decision was clearly not in keeping with the intention of the Parliament, nor with the historical rights that were under scrutiny. We also know today that the first decisions in Manitoba which invalidated provincial legislation were just clearly ignored by the legislature and the governments, and that implementation of the rights, even recognized by the courts, was absent. Now, all of our major constitutional crises have had to do with minority rights. Cultural insecurity, therefore, was created very early on by getting rid of French in Manitoba, by abolishing French schools in Ontario and in the 3 maritime provinces. French was also eliminated in the Northwest Territories, Alberta, and Saskatchewan. And that situation, and even the situation here in Manitoba, was not addressed until 1975. This means that the very legitimacy of the judicial system was put in issue. And as it turns out, the return to constitutional order was only achieved because of a constitutional crisis and through a reference to the Supreme Court of Canada. The enforcement of language rights, even after 1982, was very difficult, considering that in 1986, the Supreme Court of Canada dismissed the concept of substantive equality and recognized a type of formal equality that extended to the judicial system, bestowing equal rights on judges, government officials, as well as the right holders before the court. The MacDonald case, Société des Acadiens case, and Bilodeau case were partly reversed, but only in the Beaulac case, 18 years later. Although these precedents were not followed in educational matters with regard to the interpretation of Section 23. But why do you think we would have such decisions after the adoption of the Charter in 1986? It seems to me that Justice Betts expressed it quite clearly. It was because of the political compromise of 1867, which gave priority to Quebec with regard to the division of powers in cultural affairs. In other words, Quebec's power over its educational and cultural institutions shouldn't be interfered with by a liberal interpretation of language rights. But it is clear to anyone who's looked at the matter that language is the expression of a culture. And that is the most important factor uniting any community. The dissenting judges in Société des Acadiens were quite right. Language is essential to a community's vitality, not only as a foundation for its economy, but because of the fact that to speak one's second language to function in society means that you are accepting an inferior status for your own language. So why was it so difficult to accept that there were 2 real official languages in Canada comprised of 2 very real language communities? The minority language group always seeks to survive and live on. It asserts itself through a form of nationalism. In 1867, this is why we say there were 2 nations seeking to coexist. In 2002, the Parliament of Canada recognized the existence of what they called the Distinct Society of Quebec. In a rather remarkable fashion, the Court of Appeal of New Brunswick would later on recognize the Acadian Society as a distinct society in the Charlebois case. It refused to apply the Société des Acadiens precedent because it said that that was based on a historical compromise of 1867, while the Act of 1982 was based on a very different compromise, even though the terms were exactly the same. So history teaches us that language rights are very political. They're, in a sense, part of the political establishment. Hence, laws dealing with language cannot be structured solely in terms of the individual. And this explains why the Government of Canada really had to adopt a new Official Languages Act in 1988. Section 41 of that Act includes a duty to promote the advancement of official language communities, which is quite unique in Canadian legislation. In the Desrochers case, the Supreme Court clearly suggested that Part 7 of the Official Languages Act, the one that comprises Section 41, is now justiciable, and that it must be given a scope wider than Part 4, which only deals with the responsibility of giving services to the public in both official languages. It took a very long time in Canada to come to an understanding of the collective aspect of rights. All the same, a will to constitutionalize this new vision was apparent in the context of the Charlottetown Accord. Now, following the failure of that reform, action was nonetheless taken to consolidate the rights of the Acadian community of New Brunswick by enacting Section 16.1 of the Canadian Charter of Rights and Freedoms, a provision called into question again in 2011 by the government of New Brunswick, since defeated, which goes to show that language minorities, even in a situation such as that in New Brunswick, is never actually totally secure. You must remember that this reaction of the government of New Brunswick came after the adoption of an act called the Act Recognizing the Equality of Two Linguistic Communities in New Brunswick, a statute that created positive duties for the government, just like the ones that are created under Section 23 with regard to education. The duty to legislate, to build schools, to supervise, would take enormous proportions in the Supreme Court judgments in 4 major decisions after Maé. Maé was the first very important decision which recognized the right to management of schools by the minority. Then there was the Arsenault-Cameron case from Prince Edward Island, Beaulac, Doucette-Boudreau, and Desrochers. The court sets out clear rules of interpretation, gives priority to substantive rather than formal equality, recognizes a duty to provide institutionalized equal access to services in one's language of choice, reasserts the constitutional objective of correcting past injustices, restrains the ministerial discretion in the implementation of rights, and grants powers of review to the courts pursuant to Section 24 of the Charter. It's especially important to note that even though the rights, all of these rights are expressed in the law as individual rights, they all exist because the individuals who assert them are part of a language community that is itself entitled to recognition. In the Beaulac case in particular, the court clearly accepted that it is not sufficient for the federal government to accommodate a person requesting to be served in the minority language. Rather, the very organization of the services have to take into consideration the fact that there are two distinct language communities to be served, and that such communities are entitled to equal access to services of equal quality. It is clear, therefore, that the governments have a positive duty not to accommodate individuals one at a time, but to accommodate a whole community by giving access to that community on the same level as the access given to the majority. In the Arsenault-Cameron case, ministerial discretion is at issue. That is, the capacity of government to select the means to implement language rights. In that case, the French Language School Board had taken a decision with regard to the extension of services offered in the town of Summerside, and the minister exercised a veto over that decision. The court decided that the exercise of that veto was unconstitutional because it ignored the impact of the system on the minority community, leaving it vulnerable to the dangers of linguistic and cultural assimilation, which, of course, Section 23 is there to address in the first place. To deprive the community of that which the minority board had been created for was incompatible with the duty of advancement and protection at the very heart of Section 23. In that case, what the government argued is that it was acting fairly because it was applying exactly the same rules to the French school board as it would to the English school board. And basically what the court said, equality would be in treating them differently because each decision should address the particular situation of the group to be for which the decision is applied. The Lalonde case would add a new aspect to the analysis of language issues in the context of weak legislative frameworks. The case touches on the unwritten constitutional principles that were set out by the Supreme Court of Canada in the reference on secession, on the secession of Quebec. A direct connection is established in this instance between the duty to promote the advancement of institutional structures. The Montfort Hospital could not, according to the court, be eliminated in favor of bilingualism at the Ottawa General Hospital. The court would hold that what was at issue was the minority culture itself and the safeguarding of the Francophone heritage in Ontario. In brief, what the court states is that it's not legitimate for the government to weaken or eliminate minority institutions when government action will effectively call into question the survival of the minority. The evidence at trial established that bilingual institutions are most often unable to provide services of equal quality to a minority language group. All of this would flow from the interpretation of Ontario's French Language Services Act, and mostly the rationale for that. The court is eager to show in its decision that it's not inventing new rights. It refers to the assertion by the Supreme Court that the unwritten principle of equality of minorities is normative. And this is the very philosophy that would drive the Supreme Court to authorize later on the supervision of the carrying out of the order to build French schools in Nova Scotia. So we stand today far removed from the duty to not injure, as I might qualify it, a fact that's reasserted, that was asserted by the Supreme Court in the Lavigne case in 2002. So the freedom of action of governments, which resulted from the trilogy of 1986, is now very much shaken. The Doucette-Boudreau case, I think, put that to rest. Another important development came with the decision of the Supreme Court in the Desrochers case. In this judgment, the Supreme Court of Canada would confirm the principles of interpretation developed in Beaulac and endorse an approach favorable to the recognition of group rights. The duty to communicate with members of the public in the official language of their choice, Part 4 of the Official Languages Act, entails the recognition not only of the right of each individual to deal with the government in his or her own language and to be replied to in that language, but also to the right of the minority itself to services designed specifically to meet its own needs, the appreciation of which should depend on the nature of the services in question. When services are of equal quality, whether services are of equal quality is to be appreciated relative to a norm that accounts for the need to serve, not to accommodate. In other words, to aim for substantive equality and not formal equality. Now, obviously, plaintiffs have to adduce convincing evidence of assimilation, cultural insecurity, necessity of action to halt the loss of culture by providing institutional structures adapted to the requirement of servicing two different language communities. But evidence of the sort has been presented time after time before the courts and accepted. So why is it necessary to once again start from scratch when the fact of assimilation is so obvious? It's because the policies of governments, and especially the way their services are structured, have always resulted in the creation of a policy of the state and insidiously a national culture. The national culture threatens the minority's distinct culture because it excludes and marginalizes it. Bilingualism is not a distinctive element of a culture. It doesn't define a community. And it's been proven that bilingual institutions promote assimilation in many cases. They are practically never able to secure equal access to equal services. The Supreme Court thoroughly explained this in its decisions regarding the creation of homogeneous French language schools and especially French language school boards outside of Quebec. We've all seen bilingualism policies in hospitals and other services of that kind. We've all seen how air and railway travel, which has been subject to language requirements for 40 years, still don't meet the test of substantive equality. The social and political costs, I think, of this failure is enormous. Our problem is one of cultural identity. Loss of identity is troubling for an individual, but it's even more troubling for a community. And it's clear that Canada has opted for strengthening minority cultures or cultures of official language communities, not eliminating them. The national choice is thus to favor distinct institutions that are essential for the preservation of official language communities whenever it's feasible. This is a matter of restraint and reasonableness, where decisions have to be made, obviously, on a case-by-case basis. But it's out of the question to return to a situation where there is absolute government discretion and a premise that their only obligation is to provide individual rights. So this brings me back to the original question. Where does this idea of ours come from, that it is necessary to resort to official languages to prevent natural nationalisms from destroying the country or thwarting its normal development? Well, it comes from history. It comes from the analysis of demography. It comes from the political choices of the people in 1867 and 1982 in particular. We must therefore act in a consistent way and give ourselves the means to consolidate the Canadian francophonie and promote national unity by bringing language communities from throughout Canada to full political participation. Hence, our efforts in the realm of law should promote contextual analysis. New Brunswick is not Quebec, nor is it Newfoundland. The institutional model is more or less in place. Its fundamental value was acknowledged, of course, by the Supreme Court in Maé and Arsenault-Cameron, and especially in Beaulac. So the goal should be to achieve the greatest level of autonomy possible under the circumstances. Not the least costly, not the most manageable, not the closest to the status quo. Equality cannot be measured in dollars and cents either. In any event, one might ask, what is the price of political and social instability? It goes without saying that the relations between and the attitudes that characterize language groups should be central to the concerns of all those who are responsible for legislation. The first language laws were aimed at quelling secessionist movements following World War I. Language legislation was most often aimed at that point at reducing social tensions by minimizing opportunities for discord. But in our case, such legislation now has a broader objective, namely providing for conditions propitious to the harmonious development of different language groups and encouraging such groups to contribute fully to the economic, social, and cultural development of the entire nation. Language planning is therefore of great importance. It has a practical as well as a theoretical and symbolic facet. The language regime in a modern democracy should definitely not be based on power or population size. It should reflect the ideals that we have, the fundamental values that we hold, and of course, the requirements for a heterogeneous society. In setting goals for language laws, it's always a good thing to ask oneself, what factors will be used to measure success? Will success be defined in terms of absence of social conflict, absence of discrimination, or real equality between persons belonging to different language communities, the status and value of which shall be recognized by all. Briefly stated, one must recognize that there are latent feelings of inferiority and insecurity that continue to result from language relations. So if language legislation doesn't contribute to eliminate these, its only result will be to entrench each language group in its current attitudes concerning the requirements of a pluralistic society. Language legislation can integrate, but it can also isolate. Consequently, time should be taken to address the historical development of language relations in Canada, the social structure that characterizes relations between language communities, the social divisions that characterize the population, as well as the population's attitudes to and expectations of the political process. All these things must be taken into consideration when providing for language guarantees and deciding on institutional arrangements for regulating relations between government and citizens from both language communities. Language communities realize that it is in their common history and in the establishment of cultural borders that foster the development of the connections between them and the awareness of each of its own identity. To change the historical connections between, as well as the attitudes and self-awareness of different groups, a certain sense of history and continuity is required. Long-term objectives are necessary. One must know where the population stands relative to enduring ideological divides. What the federal language regime aims for, as I've mentioned, appears to be language security. What has been lacking, it seems to me, lies in the fact that the language options afforded to the minority have often been very limited because of the organization of the state, because of the design of public institutions. Linguistic assimilation is generally brought about by offering to the minority the advantages of full participation in public affairs at the expense of cultural and linguistic identity. One cannot speak here of coercion in the sense that the minority language group would be prohibited from using its language, but the effect is more or less the same. The best example of this was the old concept of the bilingual school. There is no single or miraculous solution to institutional problems, obviously, but the government must be consistent. It must accept that it is impossible to provide for an egalitarian scheme of collective or even individual rights without entailing some duties at the institutional level. What is very exceptional in Canada is that the courts seem to have played the lead role in developing the philosophical impetus for language rights. I believe that this philosophical basis is best explained in the Beaulac case. It's the courts, for the most part, that have defined the set of values to which Canadians are to subscribe. It's the courts that have identified the fundamental cultural realities and the heritage that we wish to protect. The fundamental value expressed in the Charter of Rights and Freedoms is one of substantive equality, but it had to be the courts to state it. So the role of the courts is capital, because they are in fact the ones that are laying down the philosophical groundwork for language guarantees. And as I mentioned at the outset, this is dangerous because the role of the court can, over time, be negative as well as positive. Recently, the courts have demonstrated great vigor in giving effect to protections, even in cases of ambiguity. As an example, I mentioned Section 20 of the Charter that was seen to be not applicable to municipalities in New Brunswick and Ontario. In the Godbout case in the Supreme Court of Canada, 3 justices held that municipalities should be subject to the Charter. Thereafter, the Court of Appeal of New Brunswick issued its ruling in the Charlebois case I mentioned earlier, in which it declined to adhere to the Supreme Court's decision in Blakey, invoking new rules of constitutional interpretation, but also the fact that the legislative intent behind Section 18.2 was clear and different than that alleged in the Blakey case in the context of the province of Quebec, though, as I've mentioned, the terms of the 2 acts were identical. Another case of ambiguity, of course, is the one regarding the Montfort Hospital. The Court of Appeal of Ontario didn't hesitate in the Lalonde case to hold that the French Language Services Act provided for equal access to services of comparable quality, even in the absence of any section equivalent to Section 2 of the Federal Official Languages Act. The court would state the following: one of the underlying purposes and objectives of the Act was the protection of the minority Francophone population of Ontario. Another was the advancement of the French language and promotion of its equality with English. These purposes coincide with the underlying principles of the Constitution of Canada. None of this was in legislation, preparatory papers, or even declarations of ministers. The court simply held that the Health Services Commission couldn't simply invoke administrative convenience and vague funding concerns as a reason for its decision if it affected the status of the minority. So finally, I must mention the Boudreau-Doucet case again, which deals with remedies in the field of language rights. The order handed down by the trial judge in that case was quite exceptional for its vagueness, and it differed very much from any kind of mandatory order that was given in education, for instance, in the Marchand case in Ontario. The judge required that the government make its best efforts, it said, to comply with its order to build schools within a reasonable time. Now, the judge realized that the government was not pressing the issue very much, so he decided to retain jurisdiction so as to ensure that the directions he would give in further judgments would be followed by the government. So he ordered that the minister appear before him periodically to report on the progress. At the Supreme Court, the issue was the following: does a superior court, having ordered pursuant to Section 24 of the Charter that a province make its best efforts to provide school facilities required by Section 23, have the authority to retain jurisdiction and require that status reports be submitted? The Supreme Court answered 5-4 in the affirmative, which, according to most, added a novel dimension to Section 24. But of course, there aren't very many constitutional rights that provide for governments to spend money and to build buildings. So I'll conclude simply by saying that it's a very complex task to implement a language regime, and that the success of the endeavor is really never totally guaranteed. Nevertheless, if the mission is well carried out, its impact can be invaluable. Ever since the first days of the colony here, governments have sought to strike the right balance in this area, and perhaps the search is not over but I think we can still rely on the assistance of the courts. Thank you.
All right. Thank you very much, Maître Bastarache, for a very, very thoughtful presentation. And we have time for questions. On a du temps pour des questions. Je dirais à peu près 10 minutes. Alors, j'encourage tous les étudiants, tous les gens qui sont ici, si vous avez des questions, je vais vous donner le micro. I'll give you the microphone if you have a question. So just raise your hand. Anyone? Yes? Okay.
Merci, Maître Bastarache. Aimé Craft, je suis avocate ici au Manitoba et je pratique en droit constitutionnel, principalement en droit autochtone, mais aussi en droit linguistique et aux aspects du droit constitutionnel. I'll switch to English because it is the language of your talk, but I appreciate a lot of the work that you've done in the area of language rights, and I want to start by thanking you for that. My question is related to the parallels between language rights and Aboriginal law. There's a lot of parallel in the sense of the foundation in culture and collective right, exercised individually. And I think it's interesting, and you note how cases that you've referred to are often brought by individuals where they're affirming their individual right that's based on a collective right. And I struggle with the distinction that happens in language rights versus Aboriginal rights, where we don't require in language rights that the person who's seeking the remedy or advancing the right demonstrate that they're actually part of the community. It's something that's absent in the legal analysis. And I'm not saying that in a critical way. I think it's a good thing that there isn't that requirement to demonstrate belonging to that group. But it's quite the contrary in Aboriginal law. And we look at examples like the test that's been established for proving a Métis right, and a lot of it is focused and is still focusing in the cases on showing that you actually belong to a community and therefore can assert a right. So can you talk about, the court's role in setting that philosophical framework and how it has gone in two different directions in both areas that frame collective rights with an individual aspect to them, and how that might be maybe the reasoning behind it and how that might be remedied or addressed in the future?
The real difference comes from the fact that the foundation for both groups of rights is entirely different. In the case of language rights, there are no rights unless there is specific legislation. So the state really, well, here, of course, in Canada, before you had any language legislation, you just went to the concept of reception of the old English laws and came, of course, to the conclusion that English is the language of government, of the courts, all of that, even if there is no local legislation. So if you want then to obtain rights that are separate or exceptional, you need legislation to oust, of course, the received laws of England. In the case of Aboriginals, it's quite the contrary. Of course, language rights being all individual rights in the way they are defined, the Aboriginal laws are all communal rights in the way in which they're defined. But they are not based on an enumeration. Other than the formal treaty rights, the general Aboriginal rights are seen as basically cultural rights that are given normative value. So in a sense, nobody can really give you a list of Aboriginal rights. And it's very circumstantial, the interpretation that is given to those rights outside, of course, of the interpretation of the specific treaties. Where there is a commonality is in the fact that even in the case of rights that are prescribed to be individual rights, they wouldn't exist if they weren't communal. You wouldn't have a right to education if you were the only person needing the education. And you wouldn't have the right even to a trial in your own language if you were the only person to speak that language. So basically, it's because you belong to a group that you have this individual right. And what the Supreme Court basically said in its interpretation of the right is that you can't really ignore the fact that the reason for the right being created is that there is a community there, and that if the purpose is to permit the community to function and participate fully in society, well, then you have to give an expansive interpretation of the right. If it wasn't expansive, you would only be accommodating individuals on a case-by-case basis. And of course, that doesn't in any way provide for any kind of substantive equality. With regard to Aboriginals, I think it's very difficult to understand how you could have an interpretation that would give priority to individual rights, because not only of the way they're framed, but because of the general purpose for which, especially in 1982, where you recognize the perpetuation, consolidation, you might say, of the rights without naming them. So in a sense, you have to say, what are those rights? Well, those rights are those that are essential to the vitality of that community, to the maintenance, the maintaining its cultural distinctiveness. And this is why we say, for instance, well, provincial legislation will apply to Indians, but not if it affects Indianness, as it was called in the jurisprudence. And this is what it really means. So it's my explanation.
Thank you. Questions?
Monsieur Angrila?
Oui.
How do you feel about this bill? I think it might be pending before the Senate. I'm not sure. That would amend the Supreme Court Act to require all new justices to be bilingual.
It's not the Supreme Court Act it would amend. It's the Official Languages Act, which provides that federal courts have to be bilingual, but there's an exception for the Supreme Court of Canada. Well, my general feeling is that in a country where there are only 2 official languages, it must be possible to have a bench of people who speak both languages. I think it's very exceptional to have only 2 official languages and 135 years after Confederation still not be able to appoint 9 persons who speak those languages. Because it is quite obvious, well, I know for having been there, that there is no way that you can function equally or have access equally to justice in either French or English when part of the bench doesn't understand the language. And it's also because of the way the court functions. The pleadings, technically you could follow through simultaneous interpretation. Now, if you've ever tried it, you will know that it doesn't provide equal access. And if you're talking about very complex constitutional issues with a special terminology, it's outside the realm of equality. Second thing, if the factums that are presented are in French, they are not translated. So the judge who can't read them doesn't read them. They are not translated. He can ask for a clerk to make a resume for him. He can ask another judge who is bilingual, what does it say, but he can't read it. The other thing is that the decision, the first draft of the decision, the one that is circulated to the judges, is not translated either. So if you're hearing a case from Quebec, a judge from Quebec is writing it, it's going to be in French, but it's not going to be translated. It is translated ultimately, but after the decision is taken, not during the process. So basically, if you're presenting your case in French, you know that certain judges can't hear you, can't understand you, cannot read your factum, and can't even read the draft decision. So it seems to me that it's not acceptable. So what is the solution? That is the other question. I think people have said, well, maybe you should appoint only people who are bilingual, and that is logical, except that it's political obstacles to it. Some people have said, well, you could put a future date so that people who want to become judges of the Supreme Court can sort of prepare for it. But I can tell you there aren't too many people who are going to be appointed there in the next few years. So I don't know who would really, at 35 years old, start learning a language in case he'd be appointed 20 years down the road. The other solution, which I think is more practical, is that to augment the number of judges on the Supreme Court. You know, we have 9 judges who sit in panels of 9, but in England they have 14 judges of their Supreme Court and they sit in panels of 5. Well, we could change. We could have 12 judges instead of 9, and we could sit 7 instead of 9. Or we could do all sorts of things of that nature which would permit us to have a bench of persons who are fluently bilingual to hear those cases that are in French.
Is it a short question or a short?
A follow-up. It was a follow-up around the state of access to justice in official languages in other courts across Canada. Because I see Renel Remier up there, who has been working on that issue, and we had him speak last year on the 30th anniversary of the Charter, and I believe that is an ongoing issue, is it not?
Well, actually, right now, the only right of access that is national is in criminal courts, but not at the appellate level. So, first level, and in fact, it is not being implemented completely, because I know of 2 provinces where there isn't a single judge that is bilingual in that court. In the provincial court, I know in the Maritimes, the provinces who have a problem can borrow a judge from another jurisdiction. So, for instance, if you want a criminal trial in the provincial court of Prince Edward Island, the judge who will hear your case is a judge of New Brunswick. But in the Superior Court, it seems you can't do that because of Section 96 of the Constitution. I'm not sure it's a good interpretation of 96, but that's the one they obtained in the federal government. So basically, you have to have a bilingual judge, and it is illegal. What they're doing now is providing those cases through simultaneous translation, because the Criminal Code says very specifically the right to be heard directly without translation by the judge.